Good afternoon, everybody. On behalf of my colleagues who are sitting on the dais, we wish you all the best to both the teams, and we would like to have your views on the problem which is given to you. And you know the rules, like what time has been allotted to you, and that way we would like to just have an overall assessment later on, but try to show your skill and your whatever preparation you have done. And we know that it's not a formal court, so as far as moot court is concerned, so there are certain marks which are given for under subheads or to different not only knowledge, the other things are also important for lawyers. So considering all those things, keep it in mind, but don't be overburdened because of this, that as if you are appearing in a very formal court, but be intense and try to perform as per your good capability. We wish you all the best. So we'll first ask the team number 1 to start, the claimant.
Greetings to the honorable members of the tribunal. The standing counsel and my co-counsel together, we are representing the claimants in the present matter of Ms. Jain and the Mosaic Holding SDN BHD and Mosaic Enterprises Private Limited. The standing counsel will be addressing the issue number 1, which is related to the parties' cross-jurisdictional objection are maintainable or not. And my co-counsel will be addressing the issue number 2, which is related to whether there is an implied duty of good faith under contract law in India or not. If the members of the tribunal may permit, the counsel would like to briefly explain the facts of the case.
Yes, permitted.
Much obliged. So in this present case is before the arbitrational tribunal for adjudication. In this present case, Ms. Jain Nandi, the claimant, is a serial entrepreneur from India. She decided to become an active investor in the blockchain startup and decentralized web. And there are 2 respondents in this present matter. Firstly, Mosaic Holding SDN BHD and the Mosaic Enterprises, which together are considered as Mosaic. In this present case, Ms. Nandi and Mr. Pradeep Jacob agreed that Ms. Nandi would become the part of Mosaic, and in furtherance of that, they entered into 3 agreements, namely, the members of the tribunal may refer to the page number 6 of the memorial of the claimant, para number 2, on which the table has been provided, in which it is clearly mentioned that there are 3 agreements in which the parties has been entered. Firstly, the share purchase agreement, secondly, the shareholders agreement, and thirdly, the employment agreement. And the arbitration clauses contained in the share purchase agreement, and the other 2 agreements are the ancillary agreements. Then out of nowhere, a termination letter was transmitted by Mr. Pradeep Jacob to Ms. Nandi on the ground that she is not giving much to the company. And then within the 17 days, a complaint was also filed against the claimant alleging theft and conversion of G-grade tokens. And in furtherance of that, the claimant has invoked the arbitration under section 14 clause E of the share purchase agreement. So for today's hearing, the 2 issues has been bifurcated. Firstly, that the parties' cross-jurisdictional objection are maintainable or not, and secondly, that whether the implied duty of good faith whether the contract has the implied duty of good faith under Indian law or not. So the dispute is regarding whether the arbitration agreement is maintainable or not, and secondly, whether the claims filed by the claimant are maintainable or the counter claims filed by the respondents are maintainable or not. Moving on to the first issue, there are a 2-fold argument raised by the claimants. Firstly, that the arbitration clause in one agreement applies to all the 3 agreements. Secondly, that the signatories to all the agreement are same, and thirdly, that the objective of all the 3 agreements are same. So in regarding to the first limb of the argument, the counsel, before moving on to any further argument, the counsel refers the arbitration clause which is provided under section 14 clause E of the share purchase agreement. The members of the tribunal may refer the page number 11 to the uppermost corner of the page, in which it is clearly referred that any and all dispute arising out of or in connection with this agreement shall be finally settled by arbitration. So the word in connection is incorporated in order to widen the scope of the arbitration disputes, and also that that the word connection is comprehensive in nature to include all the dispute arising out of in this agreement and also in connection to the other agreements. And in this particular case, the issue, the dispute has arisen out of the other two agreements, which is the shareholders agreement and the employment agreement. And also these two agreements, shareholders agreement and the employment agreement, in which the dispute has arisen out of, are the appendices to the share purchase agreement, which is provided in Annexure 1, and the other two agreements are the appendix to it. So the literal meaning of appendix according to the Black Laws Dictionary is that the appendix means the supplementary to the main contract. So in this particular case, the shareholder agreement and the employment agreement are the appendices to the share purchase agreement, in which the arbitration clause is provided, and hence the arbitration clause applies to all the two agreements as well. Also, in this particular case, both the companies, there are two respondents, Mosaic Holding SD and BHD and Mosaic Enterprises Private Limited, and both these companies are the one company is the principal is the holding company of the other subsidiary company and owned all the shares of the subsidiary company, and hence in this particular case the doctrine of group of companies is applicable. So doctrine of group of company means that two or more than two companies having the same object, working on the same objective, considered as a part of a same corporate group. So both these companies are considered as a part of the same corporate group. Also, the objective of all the three agreements was to make Nandi part of Mosaic, and for this purpose all the three formalities has been done and all the three agreements came into force. Also, the council would like to state that there are various phrases in the agreement which clearly provides that all the three agreements are interlinked with each other. So the members of the tribunal may refer to the page number 15 of the memorial of the claimant, para number 21. In the para number 21 on page number 15, this is the general method. It was held in the case of Cox and Kings Limited versus SAP India Private Limited. In this particular case, it was held that the general method to figure out the parties to an agreement, to an arbitration agreement, is to look for the entities who are named in the recitals and have signed the agreement. So as far as the recital is concerned, the recitals of the share purchase agreement clearly includes the subsidiary company as well. Also, all the three agreements were signed by Mr. Pradeep Jacob. Mr. Pradeep Jacob is a managing partner and majority shareholder in both the company, and he is the signatory to all the companies. Also, the letterhead of the employment agreement clearly mentioned the Mosaic Holding, which is the holding company. If Mr. Pradeep Jacob has signed all the three agreements, if they would have intended to make the other company non-party to the arbitration agreement, then they could have appointed the other representative. The Mosaic Enterprises, which is the subsidiary company, could have given this responsibility, or could have made any other person as the representative. Only the Pradeep Jacob has signed all the three agreements on behalf of both the companies, which is the Mosaic Holding SD and BHD and Mosaic Enterprises Private Limited. Also, the Mosaic wallets are jointly owned by both the companies. Both the companies has the access of the Mosaic wallets. So this clearly referred that both the companies are interlinked with each other, and also the agreements are in the composite transaction. All these three agreements are entered between the parties on the same date, which is the 7th September 2021, and for the same objective, which is to make Nandi part of Mosaic through various positions.
The judgment which you have, a portion of judgment you have cited, what is that judgment and when it was passed by the High Court, by the Supreme Court?
Learned arbitrator, the citation has been given on the page number 14, para number 20, in the footnotes, where it has been provided that this is the judgment of 2023 INSC 1051. INSC is the India's neutral citation system. So it was.
Then I have another question. If you kindly go through the your clause 4.3 of agreement, appendix A, shareholder agreement, as well as para 18 of employment agreement. I may read it out for your convenience.
Indeed.
The agreement constitutes the sole and entire agreement of the parties to this agreement with respect to subject matter contained herein, and supersede all prior and contemporaneous understanding. That means any agreement even done at the same time with them, agreement, representation, warranties, both written or oral with respect to the subject, everything will be superseded. Now, could not I read or could not I understand it as that the share purchase agreement was only for execution of two agreements, that is share agreement and the next is the employment agreement. Once they are agreed, this agreement goes. By virtue of this 4.3 or 18 of the second agreement, what do you want to make your comment on this?
It is not a unique case, learned arbitrator. In many cases, the arbitration clause which is in the share purchase agreement or which is in the principal agreement applies to all the agreements who are appendices to it or who are the which are the ancillary agreements to it. So this is not a unique case in which the tribunal cannot interpret the arbitration agreement to resolve the dispute arising out of the other two agreements as well.
What I understand, that particular arbitration, that is share purchase agreement, is now of no importance, have gone bad, because the two agreement which was required to be executed have already been executed. And the clause 4.3 says that if these agreements is the only guiding feature for this particular act. So now there is no share purchase agreement, that is gone.
Indeed, arbitrator.
Or that is still existing.
Learned arbitrator, arbitration agreement or arbitration clause is independent in nature. Even if the share purchase agreement has been terminated, but the arbitration clause is independent in nature and it can apply to the dispute arising out of the other two agreements. To conclude my contention, the council submits before this honorable tribunal that all these references to the agreements clearly provides that all the agreements are interlinked with each other and both the companies, both the respondents are companies are the part of the same corporate group and hence can be liable under the arbitration clause. And it was so if the council seeks permission to give the dais to my co-counsel to address the issue number 2, which is related to the whether the implied duty of good faith is in under the contract law in India or not. It was an honor pleading before you, tribunal.
Greetings to the Honorable Arbitration Tribunal. The Council is appearing on behalf of the claimant, Ms. Nandi, and would be dealing with the second issue. Before we move any further to the arguments of issue 2, the Council would be drawing out as to how the two issues are formed. Since we are appearing before the arbitration tribunal under SIAC rules, that is Singapore International Arbitration Center rules, according to the rule 19.4, there has been bifurcation of the proceedings. That is, few issues have been decided as to be heard today. The two issues are whether the parties' cross-jurisdictional objections are maintainable or not. Firstly, it would be clarified that it is not a typical normal case wherein a statement of claim is filed by the claimant and they file a statement of defense denying the claims. Herein, we have filed statement of claim, they have filed statement of defense. Moreover, in case the tribunal would decide the jurisdiction, then they have filed counterclaims and we have filed defense for that. So, there are two cases before the Honorable Tribunal for the adjudication, the claims and the counterclaims. The Honorable Tribunal may refer to page number 21 of the memorial by the respondents. By the claimants, pardon. And there is a clear table given that bifurcates between the claims and the counterclaims. If the arbitrators are on the page and they can see that bifurcation. Actually, we are claiming payment for call option, profit, incentive, bonus, just as salary is claimed by an employee of the company. And the respondents are claiming damages for breach of contract. So, they are claiming that there was a duty on Ms. Nandi of good faith which she has breached, and due to the breach she is entitled to give damages to the respondents, and therefore this issue is framed by the Honorable Tribunal whether there is an implied duty of good faith under contracts in the Indian law. As now we know the issue very well, we would be moving with the arguments. The three leg of arguments the claimants have raised under the issue are: firstly, tribunal does not have the jurisdiction over the counter claims. Secondly, no provision for duty of good faith is present in contracts in the Indian law. And thirdly, there has been no breach, and even if yes, the arbitration agreement stands valid. So firstly, the council would be clarifying that since these two cases are distinct and separate, whatever the award would be passed in reference to our claims would have no impact on the counter claims, and vice versa. That is, our claims are independent of their counter claims, and whatever the award would be given for counter claims, it would have no impact on the claims. So moving with the impact, the implied duty of good faith. Our humble contention would be that in order to determine the breach, the respondents have to submit before the Honorable Tribunal as to what express clauses are breached, rather than implying a duty, a general duty, a vague duty of good faith in the contracts. And they need to submit what are these express conditions which we have breached, and therefore we are liable to give them damages. And there is a case, that is Amit Lal Chandani Shah, wherein the allegations of fraud were involved on the claimant, and they refused to arbitrate the matter, but the Supreme Court actually overruled and said that it would be arbitrable before the Honorable Tribunal even if allegations are there, since these are mere allegations and they are not proved, and it is a practice.
Ms. Consul, where is this Amir Lal Chandani case?
Page number 17 of the memorial. It is Amit Lal Chandani Shah versus Rishabh Enterprises. The citation reads as 2018 INSC 450. And even this case is really important for all of us, that it has 4 contracts like in the present matter. 3 had the arbitration clause, 1 was still not having. But
this judgment does not refer to the implied condition of duty as you are claiming. This case has nothing to do with that. Your argument is that there is duty on the part of the claimant, right?
We are actually refuting the fact that there is duty.
That there is no implied duty. But
Indeed.
This case doesn't refer to the duty element at all.
Through this case, the council wants to highlight that the respondents are using the point that since allegations are involved, it is not arbitrable, since they need to refute the arbitration as a whole. So we are contending before the Honorable Tribunal that even if allegations are there, firstly they have filed this frivolous complaint so as to put the claimant in the bad light. So we are just humbly submitting before the tribunal that allegations will not have any impact on the claims, and that is a separate criminal case which is pending in the trial court, and whatever counterclaims they have raised regarding this good faith, that are not under the jurisdiction of the tribunal. Since
your contention is that there is no duty on the part of the claimant in terms of good faith.
Indeed.
And this you are claiming under Indian Contract Act.
Indeed.
So you believe that there is no duty on the part of, this complete faith. So what are the contracts of Uberima fights under Indian Contract Act?
Indeed. The
Isn't it that generally the duty of this good faith is, presumed? If you look at the entirety of the agreement, the employment agreement and all of that, then isn't it that it looks like a, general contract and therefore an implied duty is there?
The tribunal is very well right, but our arguments under the issue are firstly twofold. Firstly, we are refuting the jurisdiction of the counterclaims as a whole. When we would be
counterclaim will come later, but at the moment you are claiming that there doesn't exist a duty on the part of the claimant, and that is you are claiming under Indian Contract Act. And the way the whole contract has been finalized, employment, shareholders agreement, and all that. Isn't it that, the general implication is that there is some kind of an, it's a contract of Uberima fights basically. Two people coming together, participating in a business and referring to several agreements and all that. So how do you deny that?
The council understands the concern of the Honorable Tribunal. However, we are not in staunch opposition to the point, and we would not be very negative on the point that there is no implied duty of good faith. But our humble contention before the Honorable Bench is that this is a premature stage. They are using this implied duty factor so as to have...
Please proceed with your argument. Please proceed.
So our humble contention was this only, that the issue is actually attached with counterclaims only. Their entire attack is on the point that we were under a duty and there has been a consequent breach and therefore we are liable for damages. Our humble contention is that counterclaims directly relates with the criminal case, and criminal case is already pending before the trial court, and therefore since the tribunal does not have anything to do with the criminal case and they are solely here to determine the claims of the parties. And moreover, this is a premature stage. If they even wants to arbitrate on the matter that there has been breach, they need to wait for the judgment passed by the tribunal, as the tribunal would be coming up with the judgment whether we have done the stealing of G-grade tokens or not. When there would be a judgment formally that yes, we are offender or we are not the offender, then the breach can be decided. But this is not the correct stage, and therefore, and firstly they are not on the arbitration, and therefore they can file the damage suit in the civil court. Moreover, as far as implication of terms are concerned, since we all know that express terms are to be given due diligence in the contracts, and implication of terms is something that would mean rewriting of the contracts. And if the Honorable Tribunal may refer to page 23 of the memorial, there is a case, Philips Electronic Grand Public SA versus British Sky Broadcasting Limited. The citation reads as 1995 EMLR 472. And the relevant lines reads as, the court's usual role in contractual interpretation is by resolving ambiguities. And the last second line is, it is because the implication of terms is so potentially intrusive that the law imposes strict constraints on the exercise of this extraordinary power. And therefore, implication of terms cannot be done this way. Either it must be so important that the contract goes without it, and therefore generally a general rule is that the court will not rewrite the contract. Also, there is a legal maxim, expressio unius est exclusio alterius, which means when the parties to the contract mention specific terms in a contract, it suggests deliberate exclusion of any unarticulated obligations. And therefore, if they have not expressly written that that the Nandi would be under a duty of good faith, they cannot claim it, and therefore they are using this loophole. Firstly, they are using this loophole as to argue that why they have not done the performance of the contract, that since we have breached the contract, they were not bound to do their performance. And secondly, they are using this loophole to get damages as well.
Section 223 of the Contract Act provides some provision with reference to good faith.
The tribunal is very well right. The bailor-bailey relationship and various relationships indeed work.
Bailor-bailey relationship, that is 178A.
Yes, indeed.
I am talking of 223.
The council is unaware of the exact provision section 233, but we know that yes, there are certain sections in the Indian Contract Act that indeed are based on good faith, but we have to be strict to the contract that we are on. This is not having any express duty. The contract at hand is share purchase, shareholders and employment agreement.
What is section 10 of the Contract Act?
It talks about the essentials of the contract, that the contract must be having a legal objective, the parties must be competent, and the basic rule that it should be enforceable by law, etc. The essentials of the contract are there.
Whether good faith is not a component of a valid contract, that somebody in his mind has a device, to fool another party or to cheat them, and there is an element of dishonesty at the initial stage. Maybe it's a commercial understanding, right? But a party knows that ultimately what we are agreeing to somebody else, we are not going to fulfill it. They have something in their mind. So whether that good faith is not a basic component of any contract, otherwise the very edifice of a contract goes away. So what is your answer to that? So if somebody at the stage when enters into a contract, has a belief in his mind that I am entering into a contract which will never be fulfilled by me, and the other party will never be able to enforce it. So whether in such circumstances, the good faith is not an inbuilt basic requirement or not. That's what I was asking.
Indeed, the Honorable Tribunal is very well right, and we from the very beginning are not in total contravention to the point there is no good faith. We are saying that yes, the contracts are based on good faith, but here we need to see it in context of the counterclaims, that the issue is present at the present matter. We are only contending that this issue can be looked upon only when this is the correct stage of examining the counterclaims and they are not within the jurisdiction of the Honorable Tribunal, since it completely pertains to the criminal case.
Right. Anything more you want to say about this? Like what is the difference, in reasoning which is given by other courts in other countries about good faith, where they are treated as an inbuilt condition of a contract, and what is the condition which has been interpreted in India, in Indian courts, like what is the good faith has to be construed?
Since
Can you make a distinction?
Since the judgments are really vast in the Indian judiciary, we can find judgments for both the sides. Firstly, that yes, and we are also submitting to the point that yes, good faith exists in the contracts. But there are also points that we need to be restrained of the fact that we not imply rewriting of the contract or any certain fact that would amount to go beyond the contract.
Our question is that, do you have any case law in your favor by any of the High Court or Supreme Court of India where they say that the good faith is not a duty of a person who signs the contract? It's not an implied condition that good faith, if not there, will not be invalid for entering into a contract. Is there any judgment by the court?
You can rephrase it and understand it if the good faith can be excluded from the contract. Please proceed.
Which supports your content. Yes. Of course, you have a right to make a submission, and it's not necessarily there should be precedent. Only good argument make good precedent. But we are asking you whether there is any discussion by any Indian court on that. Because see now, in today's world, all our economic, these transactions are taking place. Now there is a commercial litigation everywhere. So if we presuppose that this good faith is missing, so then that means now whatever people are entering into contracts, those are no contracts. So we are asking you whether it has been interpreted by our courts or not. I have any idea.
The issue must have been interpreted in various cases, although the council is unaware of that particular case, which refutes that there is no good faith in the contracts, and we are also not contending the point.
If you have any other case which the respondents are relying, which you want to say that no, this is not applicable. They are also relying certain case law which says that no, the good faith was missing, so everything was not there. So do you have anything to say on that?
The council is not having that particular case, but could I be permitted to cite a few cases that we have that would be some The Honorable Tribunal may refer to page 27 of the memorial. And the case is Rashid Raza versus Sadaf Akhtar, para 4 cited part in para 67. The principles laid down in this appeal make a distinction between serious allegations in support of the plea of fraud as opposed to simple allegations. Two working tests laid down in para 25 are: does this plea permeate the entire contract and above all the agreement of arbitration, rendering it void, whether the allegations of fraud touch upon the internal affairs of the parties inter se having no implication. So the loophole they're using is that we have breached the contract. But our humble contention is that from the past 3 to 4 years, the claimant is doing everything that she is obliged to do. And therefore, we have not breached the contract in its entirety, that they didn't perform the contract on their side. And this is the humble submission. If the Honorable Tribunal would permit, the Council would begin with the prayer. In the light of issues raised, arguments advanced and authorities cited, it is humbly prayed that this Honorable Tribunal may kindly be pleased to declare that the jurisdictional objections filed by the respondents are not maintainable and the counterclaims are not sustainable and the claims are under the jurisdiction of the Honorable Tribunal. Secondly, declare Mosaic Holdings is liable to make payment of a total purchase price of 1,82,40,000 rupees for the call option in accordance with shareholders agreement. Direct Mosaic Holdings to pay the profit in accordance with the shareholder agreement. Direct Mosaic Enterprise to pay incentive bonus in accordance with employment agreement. And Direct Mosaic to compensate Nandi for damages and interest resulting from breaches. It was an honor arguing before the Honorable Tribunal.
Thank you. Good job done.
Warm greetings to the honorable members of the tribunal. I am the first counsel on behalf of the respondents. The respondents in this case are Mosaic Holdings and Mosaic Enterprises. I am accompanied here by my fellow counsel, counsel number 2. In the present case, honorable members, just like the claimants pointed out, we have 2 issues. I will be dealing with issue 1 for the first 15 minutes and my fellow counsel will be dealing with issue 2 for the next 15 minutes. Honorable members, I will prove to you how the respondents' cross-jurisdictional objections are maintainable. We contend that the arbitral clause in the share purchase agreement cannot extend to the shareholders agreement and the employment agreement. We contend the same in a threefold manner. Firstly, the present disputes do not arise out of and are not in connection with the share purchase agreement. Secondly, the dispute resolution clause of the share purchase agreement cannot extend to non-signatories and the group of companies doctrine cannot be invoked in this case. Thirdly, the dispute resolution clause should be rendered ineffective upon the completion of the share purchase agreement. Honorable members, if you have any questions with respect to the facts of the case, feel free to ask them.
No, you go ahead in your manner.
No, but who is a non-signatory you are referring?
The non-signatory, honorable members, the share purchase agreement.
Because this is one single company, and it appears to be one single entity. The kind of a difference that you are making is actually artificial.
Honorable members, the share purchase agreement was entered into between the Mosaic Holdings and Ms. Jain Nandi. However, if we look at the employment agreement in this case, it was entered between Mosaic Enterprises and Ms. Jain Nandi.
So, look at the paragraph 4 of the statement of facts, which is the commonly admissible facts, wherein and read it out. The share purchase agreement provided that Nandi and Mosaic Holdings will enter into shareholders agreement as provided in Appendix A to the share purchase agreement, and Nandi and Mosaic Enterprises means all the 3 organizations have been put together, and you can read it with several other provisions in paragraph 14, where there appears to be the kind of a distinction you are making is actually artificial, and this one single entity. So there is no non-signatory to this agreement.
Honorable members, so as far as the share purchase agreement is concerned and its signatories are concerned, if I could please take you to page number 7 of the case file. Of the case file. It states that the share purchase agreement is entered into by and between Mosaic Holdings and Ms. Jain Nandi. Honorable members, as far as the invocation of the group of companies doctrine is concerned in this case, to answer your question in light of that, the group of companies doctrine in itself provides that the non-signatory must have implicitly consented to being arbitrated in the present matter. Honorable members, if I could please request the courtroom officers to provide the compendium to the tribunal. Honorable members, in the chlorocontrols case, if I could refer you to page number 23 of the compendium. Unfortunately, we only have one copy of the same, so I will quote it for you. The MTNL versus Canara Bank case, in fact, page number 23, if you are with me. I quote, it was held, the parent or the subsidiary company entering into an agreement, unless acting in accord with the principles of agency or representation, will be the only entity in a group to be bound by the agreement.
You're not getting where it is this?
MTNL versus Canara Bank case, sir, page number 23 of the compendium.
This is the compendium?
No, sir. The compendium is with sir.
Only one compendium.
And I think
Apologies,
page,
Mr.
yes, all
Arbitrator
all right.
and Madam.
But I am not getting your page 23 as well. It's,
But
one
whether
second.
you go to this clarification,
Yes, on.
second,
इसको बाद 26 है ना.
the respondent's objection are untenable under the governing law. See, clarification number 2.
Honorable member, we don't have a copy of the clarification, but if you could please read it out.
You don't have copy of clarification.
The clarification.
You seek the clarification. See?
You could.
दे दें. लो,
ये दे दीजिए.
Yeah, just have a copy. There's a clarification is there.
You seek the clarification.
Madam Arbitrator, this is not in context to the current question. The current question is regarding the group of companies doctrine and whether the same can be invoked. It is also regarding the independent nature of Mosaic Enterprises with respect to Mosaic Holdings. In the present case, the non-clarity in the clarification is regarding the grammar per se.
Answer is
Yes.
there. Answer is there.
Madam Arbitrator, it says that the plain language of the arbitration agreement makes it clear that it extends to any and all claims arising out of or in connection with the share purchase agreement. What we contend is that the current claims do not arise out of and are not in connection to the share purchase agreement in itself. Honorable members, I will prove this to you with respect to the common object. Common object is a pertinent essential of agreements to be considered composite in nature. The objective of the share purchase agreement was the transfer or acquisition of shares. The objective of the shareholders agreement was to recognize the rights of the shareholders with respect to Mosaic Holdings. The objective of the employment agreement was to deal with Nandi's role as a partner. Therefore, honorable members, there is no overlapping right or obligation. There is no overlapping common subject matter. As a result, there is no composite agreement. In accordance to the same, in fact, in furtherance to the same, honorable members,
See
You can
whether
find-
the
Please.
whether the shareholding of these companies is by way of arrangements of having a particular number of shares, and those directors and they have a majority of shares in all the three companies. Now, how do you explain that because there are separate distinct companies which are registered and the majority shareholders are there, so they are not to be treated as a group of companies? What is the concept of group of companies then?
honorable member,
I also had one of the questions so that you can reply both. You know that the share, you had picked up one of my query as your defense which I raised to them. Now, you're this annexer 1, so I'm now putting the question to you. Annexer is the share purchase agreement. And this share purchase agreement is having the clause of governing law of disputes and all that, so which is under dispute. But this itself provides the annexes, the schedules, an appendix. Now, appendix, if are given in an agreement and saying that these document has to be executed, how they can be said to be a independent and separate agreements?
Honorable Member, in the same agreement, if I could take you to page number 7, section 3, which recognizes the shareholders agreement. The last line of section 3 is, upon such delivery, the purchaser will become bound by the terms and conditions of the shareholders agreement. It at no point of time states that the share purchase agreements clauses will remain. Honorable members, the agreements are in such a nature that after the share purchase agreement, it would cease to exist in performance. Subsequent to this, the shareholders agreement would come into performance, and the employment agreement is absolutely separate from both of these agreements. We admit the fact that they are appendices to the to the share purchase agreement. However, attaching annexures is also an industrial practice for the means of convenience. Additionally, honorable members, our opposing counsel stated the Black's Law Dictionary and its definition of appendix. However, in the chloro controls case, there were 6 agreements that were being dealt with in that case. Very similar facts to the present case, honorable members. However, Black's Law Dictionary's definition of an appendix was never recognized, not once heard. Honorable members.
Now, one more question. Now, this your share purchase agreement is being signed by Pradeep Jacob and Jan Nandi. Huh? Similarly, your shareholder agreement is also signed by other shareholders as well, Pradeep Jacob. And the third employment agreement for another company is also being signed by managing partner Pradeep Jacob. So the same man who is entering into the share purchase agreement is also head of those other 2 companies. So merely by change of a party or change of name of a company or the shareholder, as in the case of a shareholder agreement, I don't think they cannot be said to be the group company.
So the doctrine of corporate veil would protect Mr. Pradeep Jacob's position. The doctrine of corporate veil states that a company is a separate legal entity from its members. Therefore, even the founder of a company is separate from the company itself. Honorable member, as far as Mosaic Holdings is concerned, it has in fact made Mr. Pradeep Jacob the managing director. Mosaic Enterprises as well has made Mr. Pradeep Jacob as the director. However, honorable members, the sheer fact that Mr. Pradeep Jacob holds a position in both the companies does not make both the companies the same entity. And in arguendo, even if it does, honorable members, since they are parent subsidiary companies, the group of companies doctrine cannot be invoked, relying upon the observation made in the MTNL versus Canara Bank case. Honorable members...
No, one second. As per your understanding, that if there is a dispute which arises in respect of any of the clause in any of the 3 agreement which has now been signed between the parties, like the first your share purchase agreement, then the shareholding agreement, then the employment agreement. So if a particular violation takes place in a particular agreement, do you intend to say that 3 separate proceedings can be initiated, or this arbitration clause which can be invoked is in respect of the dispute which is now between the companies and this person who has entered, like Nandi, what's her name? Okay, so what is your take on that? How do you say that? Let's say there's a dispute about the employment agreement, so between the parties, like she has not been paid her money, this is what the allegation is. Okay, so now as per your understanding, there's a separate remedy provided under that. Now come to the second part, the shareholding, there's some dispute, some shares were, capital were not paid up, whatever. So for that, there's a separate dispute. Then this first is the share purchase agreement, again there's a dispute. Now, what is your understanding of the situation? That now if somebody, either you or they, if somebody has a grievance, now what is the remedy like?
Honorable member, arbitration in itself is not the norm. It is rather an exception, as if both the parties have consented to it. In the present case as well, the arbitral clause in the share purchase agreement states that any dispute arising out of or in connection with the agreement shall be arbitrated. It does not state that any dispute arising out of the relationship will be arbitrated. Therefore, honorable members, just because the companies involved are the same, the dispute cannot be arbitrated. The dispute will only be arbitrated if it is arising out of sheerly the share purchase agreement. Honorable members, additionally, if I could take you to the claims that have been sought by Ms. Jain Nandi in page number 5 of the Moot problem. The first claim is declaring that Mosaic Holdings is required to make the payment for call option in accordance with the shareholders agreement and the subscription agreement. Honorable members, this claim confines itself to section 3.01 of the shareholders agreement only. The second remedy that is being sought is to pay the profit in accordance with the shareholders agreement. This is section 1.01 of the shareholders agreement solely. Thirdly, ordering Mosaic Enterprises to pay the incentive bonus in accordance with the employment agreement. All of these claims, honorable members, are not arising out of the share purchase agreement. These claims confine themselves to only the shareholders agreement or the employment agreement.
What is the position in Indian this Arbitration Act of 1996? What is the meaning of any dispute? What is that? If there is a dispute between the two contracting parties, do you think that no, for each dispute there has to be separate arbitration, or any arbitration will take in its compass all disputes between the existing parties? What is that? Any dispute?
So the meaning any dispute, the scope of the same can be understood by 4 factors which were laid down in the Bharati Coke case. The 4 factors were: firstly, the language of the arbitral clause shall decide the extent of the disputes. Secondly, the intent of the parties. Thirdly, connection between dispute and the parties. And fourthly, multiplicity of contracts. In the present case, honorable members, there is explicit consent of all the parties to not include arbitration in shareholders agreement and the employment agreement. The explicit consent, honorable members, like I stated earlier, is in section 3 of the share purchase agreement, where they stated that once the share purchase agreement completes, the shareholders agreement's terms and conditions shall apply. Furthermore, the shareholders agreement, honorable members, in section 4.03, if I could please take you to section 4.03 of the shareholders agreement, page number...
Ms. Consul, have you seen this section 7 of the Arbitration Conciliation Act 1996? Did you see that?
The essentials of an the valid...
arbitration agreement, what is that? Section 7. Should I read for it?
The inclusion of an arbitral clause.
In this part, an arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may have arisen between them in respect of defined legal relationship, whether contractual or not. It's only legal relationship which is important, sine qua non, for referring the dispute in an agreement arbitration. That's all. So what is your take? If you go by this, they are saying that yes, we entered into agreement, there are different agreements, all right. But now dispute is to be raised. How to come out of 7? Did you see that?
Yes, honorable member, the nature of the relationship here that we are talking about, for example, Mosaic Enterprises in itself. Mosaic Enterprises is there is a master-servant relationship between Mosaic Enterprises and Ms. Jain Nandi. Additionally, honorable members, in another case wherein the shareholders are concerned, Mosaic Holdings and Ms. Jain Nandi are governed by a company and a shareholders relationship. Therefore, there is a different relationship and such a dispute cannot fall under it. Honorable members, additionally, page number 13 of the... May I please seek a 2-minute extension?
Yes, you can.
Page number 13 of the Moot proposition, section 4.03, honorable members. The last line, section 4.03a. The clause in itself states that there is superseding effect of the shareholders agreement with respect to any other agreement that might have existed between the parties.
But that must not necessarily include this particular agreement, because these are executed simultaneously.
However, sir, if we read this section, this superseding section, along with the section in the share purchase agreement where they stated that once the transfer of shares is complete, then the shareholders agreement will come into effect and its terms and conditions will apply. It is evident that the share purchase agreement submitted to this clause of the shareholders agreement as well.
Even considering that this is a memorandum, this is not an agreement, it is a mere memorandum, and agreements are to attach to it as an appendix. Even that memorandum, if keeps a condition of arbitration, and in appendix we have that 2 agreements, why not that should travel to those also and should be considered as an arbitration condition in all the 2 other agreements?
Honorable members, I will reiterate the position of law currently with respect to interconnected agreements. The present, honorable members, the present dispute does not although the words arising out of and in connection with have a very wide scope, and it has been recognized in the Renu Sagar case. However, this scope in itself is not limitless, and it cannot decide any dispute arising out of every relationship between the parties.
But the five judges bench in Cox and Kings have already settled this group company dispute.
Honorable members, the group,
company,
yes.
Doctrine.
The group of companies doctrine is a separate issue altogether. This is the issue of interconnected agreements and proving that there is no composite nature of the agreements here.
So these interconnected agreements are by group companies. So that's why we are saying that even if the group companies are there, an execution of a particular agreement is not possible without taking help of the others. Then also in that case, why not this?
Honorable members, I would like...
How you distinguish the 2024, that is the Cox and Kings case of 5 judges bench, which is a reference reply.
Yeah. Honorable member, the Cox and Kings case reiterated the 4-prong test. Apologies, I will just conclude on this line and then... Okay. The Cox and Kings case reiterated and crystallized the 4-prong test of direct relationship, direct commonality of subject matter, and there were 2 other essentials. However, honorable members, this is a cumulative test, and merely one essential of it being fulfilled in this case does not in itself trigger the group of companies doctrine.
Speak out that what they are lacking.
Yes, honorable member.
So then speak out that out of that ingredients what they are lacking.
Yes, honorable member, there is a lack of commonality of subject matter. Like I stated here, in the claims that are being sought, they are solely with respect to, for example, the incentive bonus. The incentive bonus comes solely from her position as a labor in the company or a partner in the company. Secondly, her position as a shareholder brings the second claim, which is regarding the put and call options. Honorable members, there is no commonality of subject matter because not every shareholder is a partner and not every partner has to be a shareholder. With that, honorable members, I would like to conclude. The present dispute does not arise out of and is not in connection with the share purchase agreement. The group of companies doctrine cannot be applied in the present case simply because the 4-prong essential test has not been fulfilled. My fellow counsel will argue for issue 2. Thank you, honorable members.
Good.
Mr. President, members of the tribunal, and my esteemed colleagues, a very good afternoon. I am the second counsel representing the respondent, and for convenience, we shall be referring to the respondents as the mosaic entities. This issue relates to the misappropriation of a cryptocurrency wallet key, which is the G-Grid tokens, which is the rightful property of our client. It is in that regard that we submit that the Indian law recognizes an implied duty of good faith under contracts. Now, before proceeding with my submissions, I would firstly at the very outset like to address a couple of points which have been raised by my opposing counsel. Now, the opposing counsel submits that this tribunal lacks the jurisdiction to hear this particular claim. However, it is our submission that the breach of contract must be separated from the claims of theft which have been levied by our client with respect to the action of the Delhi police, and this must be done in order to differentiate between the aspect of theft and the breach of the express provisions of the employment agreement which have been provided herein. Furthermore, the opposing counsel stated that we are using vague terms by trying to imply a duty of good faith. However, it is in this respect that I would like to direct this tribunal to page 16 of the case file. If the tribunal is with me, If the tribunal is with me.
Yes.
Now, we will be looking at clauses 14 through 16. And clause 14 states that it is hereby agreed that the company has developed or acquired certain trade secrets and other proprietary rights and confidential information. It is expected that Nandi will gain knowledge of and utilize the company's property during the course and scope of her employment with the company and will be in a position of trust with respect to such company property. Now, further, if we read clause 15, it is stated that it is hereby stipulated and agreed that the company's property shall remain the company's sole property. In the event that Nandi's tenure is terminated for whatever reason, Nandi agrees not to copy, make known, disclose or use any of the company's property without prior written consent. And lastly, clause 16 states that Nandi agrees upon termination of employment to deliver to the company all confidential papers, documents, records, lists and notes compromising or containing company's property. Now, it is in this regard that I would like to further take you to page 4 of the case file. If the tribunal is with me. Now, if we look at paragraphs 12 and 13, which are provided in the lower half of the page, we note that Mosaic Enterprises discovered that Miss Nandi had wrongfully made extra copies of 2 of the keys of the G-grid tokens and had wrongfully retained such keys. Further, if we read in paragraph 13, without the authorization of Mosaic Enterprises, Miss Nandi made use of these illegal keys to create an additional key to gain exclusive possession of the Mosaic wallet, which constitutes a part of the company property as per clauses 14, 15 and 16 of the employment agreement. Therefore, our submissions...
But Mr. Counsel, isn't it that this is part of that criminal element of the case, which is a different story altogether?
Mr. Arbitrator, while we do admit that there is a parallel claim of theft which arises in this particular case due to the illegal keys, however, we also submit that there has been a breach of a contract in relation to clauses 14 through 16 of the employment agreement, and these remedies are separate and distinct in nature and must therefore, and this tribunal would be entitled to hear the claims with respect to the breach of the terms of the contract and any implied duty of good faith which is contained therein. Now, beginning with my submissions, we will be moving forward in a three-pronged manner. Firstly, that a duty of good faith has been recognized within the ambit of the Indian Contract Act. Secondly, that Indian courts have recognized an implied duty of good faith. And thirdly, that implying a duty of good faith is necessary to preserve the intention of the parties. Now, coming first to the submission that the Indian Contract Act recognizes such a duty of good faith. Now, let us firstly look at the overarching nature of the Contract Act. If I may take a few instances like Section 10 or Section 14, which deal with free consent, which is free from coercion and fraud. Or if we look at Section 16 or 19, which talk about undue influence making a contract voidable or recession of a contract on the existence of fraud, we find that the overarching intention of the drafters of the Indian Contract Act was definitely that the parties would act in good faith. Furthermore, if we look at Section 37 of the Indian Contract Act, it talks about the performance of obligations of the parties. And therefore, it is our submission that in this respect, a duty of good faith must necessarily be implied, since the statute has an element of good faith which is inherent to that very legislation. Now, we do understand, and we would agree with our learned opponents, that there is no definition of good faith which has been provided under the Indian Contract Act. And we also admit
same is provided in General Clauses Act.
Yes, Mr. Arbitrator, that is exactly what our contention will be, that under Section 3, Subclause 22 of the General Clauses Act, the definition of good faith has been provided, and it would include all acts done in honesty or fairly, and would also include acts which are done negligently. Now, we submit that by this particular standard, we can evaluate the present dispute at hand. Now, if I may reiterate the facts which I had just taken the tribunal through, it is clear that Ms. Nandi had made illegal keys and took sole possession of the company's property in clear contravention of clauses 14 through 16 of the employment agreement. And it is therefore clear that such an act can never be considered to be one done honestly or fairly, and is definitely not an act which is negligent in nature, as it was done with full awareness. And Ms. Nandi was only hired because of her expertise in cryptocurrency, and therefore claiming negligence as an expert is something which would be which would not be believable by any reasonable person.
Well, Mr. Consul, as far as this aspect is concerned, that she has allegedly indulged in having the extra keys, and then she misused it, and there's a criminal breach of trust, and there's a theft also. So these are the constituents of a criminal act, you can say. For that, the separate remedy has been taken by your party. Okay. Now, question is, in respect of her claim, if it is in terms of monetary claim which she says which she is supposed to get and she did not get, whether you can oust the person from claiming arbitration by saying, no, you are not acted in good faith, so at the time of inception of the contract, so you are excluded. What do you say that? This, or we can suggest we can give you a lead. Any act which has both the ramifications, criminal as well as the civil, or let's say in terms of money which somebody is denied as per the terms of the contract, how do you diverse the proceedings of arbitration by saying that somebody has not acted in good faith, somebody has violated the criminal law, somebody is not acted in a good faith? So can we oust the jurisdiction of arbitration on that count?
Mr. Arbitrator, to answer your query, I will be providing a threefold answer. Firstly, that the action with regards to theft and with regards to the breach of contract are separate and independent in nature. Secondly, that we are not attempting to oust arbitration as a mode of dispute resolution. It is only our contention, and as my co-counsel had stated, that this arbitration agreement should only be with reference to the disputes which have arisen in the share purchase agreement. Now, the current dispute at hand is one which arises out of the employment agreement. Now, since this tribunal has taken the liberty to draft the first two preliminary issues, and one of them which relates to the implied duty of good faith, therefore, we are here to exercise our right and put forward our defense with respect to that. Now, moving to the second prong of my argument, that Indian courts have recognized an implied duty of good faith. It is in this regard that I would like to make reference to a case of the Delhi High Court which was decided in 2010 and further reaffirmed in 2014 by the Supreme Court of India. Now, this case is the Association of Unified Teleservices versus the Union of India, and this may be found on pages 55 and 56 of our compendium. Now,
and where in the memorial? Memorial.
In your memorial, which is the page, which is the para? Which is the para? Starts from page 23, right? Yeah. Principle of good faith is generally enshrined in the ICA, then it starts from there, right?
Mr. Arbitrator,
you have this pink.
Just can I have a second to just look?
Please.
Why not? can take from other side, no issue. Give him this.
You can take from us.
No. All right.
Yes, Mr. Arbitrator, you may find it on page 26 of our memorial.
Right.
And you may see its mention
Para 65.
in paragraph 65,
Yes.
which follows through to the next page on paragraph 27.
Yes.
So, it is our submission that, if I may just give a brief of the facts of the case so that you may better understand the, so the court quite frankly stated, and I will just quote, they stated that every contract contains an implied covenant of good faith and fair dealing, obligating parties to refrain from actions that would undermine or harm the other party's right to benefit from the contract. Now, it is in this regard that we should read in an implied duty of good faith. Further, this was also the intention of the parties. Because if we look at clause 16, which is provided on page 16 of the case file, if the tribunal is with me. Now, if we read the last sentence in the third line of that clause, it reads paragraph number 16 on page 16 in the case file, the Moot proposition. It reads that Nandi recognizes that violation of covenants and agreements contained in this section may result in an irreparable injury to the company which would not be fully compensable by a way of damages. Now, given the far-reaching language which has been used in this particular context, it is our submission that given this case and the wording of the agreement, it is only clear that the intention of the parties was in consonance to begin with, and that an implied duty of good faith must be taken into effect. Lastly, I will cite one more case, which is the Nava Power Limited versus Punjab State Power case, where the Penta principles of business efficacy were identified.
Refer to page and paragraph of your memorial, please.
Yes, Mr. Operator.
Yeah, this is in your hands. Perfect.
Yes, Mr. Arbitrator. If I may take you to page 31 of the case file.
Yes.
It is citation number 93 contained in paragraph number 84.
84.
Yes.
Nabha Power Limited.
Yes, Mr. Arbitrator. Now, this particular case had made a reference to a decision of the UK courts, which was the BP Refinery versus Shire of Hastings, which has been cited on the previous page of our memorandum, and it provided for five conditions which are required for implying a term into a contract, and we will submit that this has been fulfilled in this present case. Firstly, it states the five-pronged test states that the term must be reasonable, it must be necessary to give business efficacy. Thirdly, that it goes without saying, it must be possible to clearly express it, and fifthly, that it must not be in contravention of any of the provisions which are contained in the contract. It is our submission that it is very clear that given the language of clauses 14 to 16 and the surrounding circumstances under which Ms. Nandi was employed in Mosaic Enterprises, that all five conditions have been met in this present case. And it is with this that I would like to conclude my submissions if there are no further questions from the bench of the tribunal.
What about your counterclaim? On what basis you are resting your counterclaim?
Mr. Arbitrator, if you could repeat your question, I couldn't.
I said, on what basis you are resting your counterclaim?
Mr. Arbitrator, we are resting our counterclaim on the very basis that this tribunal has the jurisdiction to rule over its own jurisdiction, which is the competence principle, and therefore
that's about the jurisdiction. I am asking you that you are asking that this counterclaim which you have put forward. Now, what is the basis of that? This is what I am asking.
You also claimed something
Like,
in counter.
yes, Miss.
They have yet not claimed. They had said that we will claim later. In case if it has been held that jurisdiction is there.
so the stand of your respondent is that if this objection is accepted, then there is no question of counterclaim, right? If the claim is dismissed. And then, otherwise, if it is allowed, your objection is turned down.
Yes, Mr. Arbitrator.
Then you will put forward your counter.
Yes, Mr.
That's your stand.
Yes.
All right.
Now even if for this good faith, whether it goes in your favor or in their favor, it's not going to affect the jurisdiction. Jurisdiction issues and entirely different.
Yes, Mr. Arbitrator. Yes. Thank you.
You because it was to argue. Now anything in rebuttal you want to say?
Mr. Arbitrator, if I may proceed with my prayer.
Prayer is fine.
Prayer is fine.
We understand prayer.
Okay.
They have also made out a prayer. They have asked for the degree when it's a only issue of jurisdiction. So restrain yourself only to the jurisdiction issue because we cannot pass degree now. We are only deciding jurisdiction.
Anything, yes.
The council acknowledges the time constraints and would be limiting itself to some points present in their prayer. Actually, we would clarify according to the Moot problem, the counter claims are filed according to the rules pre-handedly only. Both are to be adjusted together under section 20.3 of the rules that today only you will be determining the jurisdiction. In case the jurisdiction would be determined, they had to directly argue on the counter claims, and otherwise why would have been the second issue framed out of the counter claim of that criminal matter?
But that we already, when we pass an order of jurisdiction, this is the preliminary issue under section 16 of Arbitration Act or otherwise. But until that is decided, the other things, how will be taken?
The preliminary hearing is already been done, the issues are framed, and according to the rules, both are simultaneously together before the honorable bench. And we would point out something in their prayer. Prayer is something for which we appear before the honorable tribunal, and if the relief we want to seek is not present in the prayer, there is no sense of arguing before the honorable tribunal. They have not asked for dismissal of our claims. If the honorable bench may pay heed, they have not asked for dismissal of the claims since it was to be determined that if jurisdiction is there and without jurisdiction. Secondly, they have not asked for sustainability of their counterclaims on merits if the jurisdiction is determined. And therefore, their prayer is having defaults, and that would render their entire argument ineffective. That was the rebuttal. Again, it was an honor appearing before the honorable bench.
Members of the tribunal, we would just like to provide one point of rebuttal. That is the issue which they have contended is present in our prayer. However, it must be noted that only 2 questions have been referred to this tribunal at this particular point, and therefore our prayer is limited to that.
Yes, everybody has concluded. Chalo, we wish you all the best, and since you are reached to the finals, so you all are good, but declaration result will be a formality, we can say, but nobody is less, nobody is more, so everybody is good. Now leave it to us that formal job which we have to do, we'll do that. So you are free from our side, and we all had good, pleasure of hearing you, and see, we can understand, all of us, this Moot problem which is given to you is a really complex. It's not that simple. So for that, if you are prepared from all these angles involving case law also and the international law also, so that shows that you people have prepared very well, and we wish you all the best. All right. You've done it? अच्छा.
ये लो. अच्छा, TC40 you are okay. And TC20. This is okay. This is okay. Controversy.
We know we can do it here. You ask them to go and there's no issue. Huh? What for? No, time everybody is followed. No problem. No problem.
वैसे ही बंद कर.
उसका एडिशन तो कर लेंगे.
हाँ, कोई वो कर ले, अपने आप कर ले.
आपका शुभ नाम?
अमरपाल सिंह. मैं वाइस चांसलर हूँ NLU लखनऊ. This is my card. It's fine, man. आपके बारे में वहाँ काफी सुना. Thank you. As an advocate, as a judge, you have served so much. I can imagine. Long time, 45 years. दोनों बच्चे रोटी में अच्छे हैं. बच्चे तैयारी बहुत अच्छी कर रहे हैं.
मतलब आपके क्वेश्चंस को ऐसे भी करें, लेकिन आपकी क्वेरीज को हैंडल कर लें.
क्या सब क्या है? हाँ,
कि क्या है? Try to satisfy the bench.
Absolutely.
रहने वाले कहाँ के आप?
मैं वैसे मेरा जन्म उत्तर प्रदेश का है. मैंने 20 साल राजस्थान में बीकानेर जोधपुर. बीकानेर डूगन कॉलेज में था मैं 10 साल. किस पीरियड की बात कर रहे हैं? 95 to 2005 I was there.
95 to 2005.
5. And 2005 to 2010 I was in Jodhpur.
I left in my family. I was posted at Nagore in 94 to 96.
I appreciate it. Nagore.
So I remained 2 years posted there in
I appreciate it.